Hello, all. Welcome back to One Stop Law. In a historic judgment on 29 September 2022, in the case of X versus Principal Secretary, Health and Family Welfare Department, Government of Delhi, the Supreme Court of India has ruled that all women in India have right to safe and legal abortion. A bench comprising of Justices D.Y. Chandrachud, A.S. Bopanna, and P.B. Pardiwala have held that unmarried women can seek abortion of pregnancy in the term of 20 to 24 weeks arising out of a consensual relationship, and that making an artificial distinction between married and unmarried women will be considered unconstitutional. I have discussed this judgment in details in my previous video. I will give the link of that video in the description box. You can check that out. But in the same judgment, in another part, the court has made very significant observations on marital rape also. And in this video, I will take you through that part of the judgment. Let's get started with the video. In the recent landmark judgment on abortion law, the three-judge bench of the Supreme Court, comprising of Justice D.Y. Chandrachud, Justice A.S. Bopanna, and J.B. Pardiwala, the bench has also stated that under the Medical Termination of Pregnancy Act, the rape definition must include marital rape too. The court has observed that sexual assault or rape under the Medical Termination of Pregnancy laws includes marital rape. The bench has stated that the wives who conceived as a result of forced sex by their husbands will also be considered survivors of sexual assault, rape, or incest as defined under Rule 3B, Clause A of the Medical Termination of Pregnancy Rules. For the context, Rule 3B, Clause A lists the categories of women who can seek abortion between the time of 20 to 24 weeks of pregnancy. In this regard, Justice D.Y. Chandrachud had said, "We would be remiss in not recognizing that intimate partner violence is the reality and can take in the form of rape. The misconception that strangers are exclusively or almost exclusively responsible for sex and gender based violence is a deeply regrettable one. Sex and gender based violence in all its form in the context of the family have long formed a part of lived experiences of women." So, pointing to the abortion rights of rape survivors, the court said that married women may also form a part of the class of survivors of sexual assault and rape, as it is quite possible that women may become pregnant on account of non consensual act by their husband. In this context, however, the court said that the meaning of rape must include the meaning of marital rape solely within the ambit of the MTP Act and rules. The bench further underlined that the Indian laws existing as of now have recognized various forms of familial violence. Elaborating on the exception of marital rape in IPC and its effects on the Medical Termination of Pregnancy Act, the court said, and I quote here, that we have also briefly touched upon the exception 2 of section 375 of IPC. Notwithstanding exception 2 to section 375 of IPC, the meaning of word sexual assault or rape in the Rule 3B, Clause A includes husband's act of sexual assault or rape committed on his wife. Elaborating on the rights of a married woman to terminate pregnancy, the court said, married women may also form the part of the class of survivors of sexual assault or rape. The ordinary meaning of the word rape is sexual intercourse with a person without consent or against their will. Regardless of whether such forced intercourse occurs in the context of matrimony, a woman may become pregnant as a result of non consensual sexual intercourse performed upon her by her husband. Therefore, we see that as a part of this landmark judgment, rape for the purpose of MTP Act from now includes marital rape, and married women can also seek abortion of pregnancy from forceful sex by their husband. It is very pertinent to note that the justices here agreed that the abortion laws in India need a change according to the social realities, which means that under the MTP Act, the definition of rape will now include marital rape. Experts say that this observation is or will pave a new way for later judgments, because we should not forget that till date it is very unfortunate that marital rape is not recognized as a crime in India under the present criminal laws. So in another way, this judgment is very remarkable. That's all for this video. In my next video, as a concluding part of this judgment on abortion law, I will deal with the impact of this landmark judgment. Till I see you in the next time. Thank you all.